Keith Hoffman from the Lundquist Institute and myself are going to present a little bit on legal strategies. At least what I'll be speaking to is company legal strategies for a life science company from the company perspective, and specifically with respect to in-licensing technology from a university. We thought that would be an appropriate topic, considering that all of the groups today that are presenting are aligned with one or more academic institution or research institution in Southern California. So I'll be presenting more on the company perspective and what an early stage company should be thinking about when approaching a university to potentially in-license a technology. And Keith will be speaking more from the technology transfer office's perspective on behalf of the university or the research institute as to kind of what the expectations there are on that end. So I've been speaking a lot. Keith, do you want to go first?
Yeah, no, that's totally fine. I can go first, but remember my last slide talks about a slide that you gave. So I'm happy to go first. Or you could also go to the restroom during my talk if you want, since I know you can the whole damn. So yeah, I can start if you like. Let me.
Sure. Yeah, go ahead.
So my name's Keith. I run business development and tech transfer at the Lundquist Institute, which is an institute in Southern LA. And I'll talk a little bit about us, but always with the framework of this is what tech transfer offices do in universities and institutes. So while I may be giving specific examples around us, hopefully the lesson is much broader. So what I'd like to do, I'll take a little outline of what we're going to see here. I'm going to talk about our pipeline and then sort of the duties of a tech transfer office, what we really do, and then a little bit more about tech transfer office or tech transfer with a view to what infrastructure and mentoring can do. So not just typical sign a license and have a tech transfer deal. I want to tell you a little bit more about some other things that go along with what I consider tech transfer and how we are doing that here at the Lundquist. So first, very, very quickly on us, we have 700 patent applications. We publish almost 500 papers a year, 400 total researchers. Around 120 of those are what we consider our principal investigators. We've done 14 spin-offs in our history, and we're going to start doing a lot more of those. And we conduct around 150 clinical trials a year, mostly phase 2 and phase 3. Our annual budget's around 90 million. And importantly for this talk, almost 20 million a year is coming from tech transfer revenue. So that's our average for about the last 5 years. So it's a considerable part of what we do and what our budget is. A number of things you know us for, even though you may not know us. We invented the cholesterol test, the entire concept of paramedics, the first lung surfactants, and then we have 4 FDA-approved therapeutics and 1 FDA 510 cleared medical device. And here are the products over here. I know Kythera was mentioned in a couple previous talks there. That actually started with us. So did Alderozyme and Dari Tepeza and QT Medical. So I'll talk a little bit about those and how they play into tech transfer. So here's our pipeline. And as you can see over here on the right side is the products that we have, Alderozyme, Kybella, and Dari Tepeza, et cetera. And so what's interesting about this chart is that about half of these companies are spin-off companies out of the Institute, and others are ones that we license products to. So we on a case-by-case basis, will either spin something off, license it to them, or if it's appropriate, license it to a bigger company. A lot of what people believe tech transfer is when you get to this column here. If it's licensed out, they consider that tech transfer. That is certainly a very important step. But to me, anything we can do to help move this path all the way to product is also tech transfer. So I'll talk about that and how we engage with that. So again, sort of half of our companies out licensing, half spin-offs. This list could go much further with some of our early stage stuff, but this is the stuff that's really got a lot of traction at the moment. So what does a tech transfer office do? It identifies, protects, and commercializes. So obviously the IP part, everybody knows that. We file patents, we prosecute patents, et cetera. But also it's really important in an institute like ours and in universities, for the tech transfer offices to go out and meet with the investigators to help foster intellectual property. And what I mean by that is that a lot of times investigators don't even know what they're working on might be something that should be protected. They're not trained to think in those ways. So if you go out and help them think of those processes, then you really can foster intellectual property. We also want to make sure that inventions are not lost. And I'll talk about two biggies that were lost at our institute because people publish before you can file patents, et cetera, or simply it was never developed at all with a commercial bent. And so the other thing that we do, and a lot of tech transfer offices do, is we will help find commercial pathways. We'll actually help our licensees along either with staffing or with funding introductions, et cetera. So those are all important things that tech transfer encompasses. And I wanted to give an example of what translation means in the technology transfer game. So this is our drug, Alderozyme, that's marketed by Sanofi Genzyme now. So what happened here? So these poor kids are missing one single lysosomal enzyme. And in years past, they would pretty much have been dead by 5 or 6 years of age. It's a terrible inherited disorder. One of our investigators said, well, what if I could exogenously make up that enzyme? In other words, give it to them and see if it fixed the deficit. So lo and behold, that is what happened, and it turned into the drug Alderozyme. But all these steps need to go, and all these are part of transfer. So can we actually produce the enzyme? Will it work in cells? Will it work in humans? Is it safe? All of that's the normal thing you think about. But then the other parts that come into whether this could actually be a commercial product is, it's great, there's an enzyme, but maybe you can't manufacture it. Maybe you can't scale up. Maybe you can only produce microgram quantities of it. That wouldn't be a therapeutic. Can it be marketed? Would anyone pay for this? Would insurance companies pay for this? All of those are questions. And especially the last three here at the bottom that many startups don't ever think about. They think they're going to figure out an unmet medical need, but then they don't think about this part. So I encourage you all, when you're starting out, to think about the end. Who's going to pay for it? Could it be covered by insurance? Could it be manufactured? Those are important things to look at, I would say, early on. So that's sort of what transfer means to me. Now here's money gained on the left side. A lot of our FDA approvals, we get royalties, milestones, et cetera on those, which is great. That money goes right back into the institute. But then money lost. Back when we invented the cholesterol test many, many years ago, and when we invented some of the first aortic stents, there was no real tech transfer office at the institute. None of those things were patented. And so that money was never been able to be returned back to the institute and drive further research. So this is a lesson that we learned long ago. Finally, I'll turn to infrastructure. We have a brand new building there, 4 stories. The entire 3rd story of that is an incubator, so 18,000 square feet. Biolabs, which has about 9 other incubator facilities across the country, they are the operator of the space and have just done a great job. It's been a great partnership with them. We have 21 companies in the space now, another 2 coming on very soon, and we probably can be maximum capacity at around 30. Been open just 1 year, and we've exceeded all of our expectations, and it's a really lovely space. The reason I bring that up is not just to tell you about it, but to talk about mentoring and infrastructure. So again, we have provided this infrastructure. It is for companies that spin out of our institute, but it's also open to anyone in the world. It's quite an actual international flavor in there already. And what we have there is we brought on mentoring. So LARTA is an institute in Los Angeles that is the largest mentoring group paid for by the government for companies that win S grants, so SBIRs, STTRs. We brought their program to our institute, put 4 of our own spinoffs through it. It went extremely well. So then we decided to enhance the program, expand it. We're now bringing it to the incubator. It's sponsored by Gilead, which is great, and it'll be mentoring. So again, this helps with tech transfer because if you've transferred the technology to a startup group, but they don't have the business skills and the knowledge to push it forward toward commercialization, you really haven't done tech transfer yet, because to me, it's not till it's a commercial product that you've actually accomplished something. So that's a really important program. So again, I bring these things up to show you infrastructure and mentoring can be an integral part of the technology transfer process. Now, we'll get to Matt's slides in a minute, but I just wanted to, he's got these terms here that he lists in his slides. And I wanted to just talk about how we do things and how other tech transfer offices do things. Upfront fees, those are pretty standard. But in some cases, if it's just a couple founders, you really believe in what they're doing, they haven't got any money yet, it's obviously hard to ask $20,000, $50,000 for them. So a lot of times what you can do and what you can negotiate for, if your university or institute is up for it, is just take that upfront in equity. So if you're going to get a certain amount of equity, add on some to not get the upfront, or make the upfront due in a fair amount of time. Equity, I think this is really important for me always. I think it aligns the institute and the university with the startup in a way that they wouldn't normally be. For us, since we're an owner in our own spinoff companies, if they miss a milestone payment or they're a little late on getting us patent costs, et cetera, we're more forgiving. We can come up with creative ways for them to make up that deficit. But as an owner, you're a little bit more aligned in your goals. Milestones, I think the only thing I would say on this is a lot of times you see clinical phase milestones. And again, if a company's only in the seed stage or the Series A stage, it's pretty hard for them to come up with some of these $500,000, $1 million milestones. You could argue for more sales milestones, so you're going to have a royalty plus sales milestones on top of that. So I think you should try to be creative and think about where you might be when you're going to hit those milestones. And then, Matt will cover all this in detail. I think the final note I wanted to make is the pie charts on the right there. I see this far, far too often. You have founders that don't want to give up any equity. They want to do it all on their own. And if purple represents what they're going to have, at the end of that process, they'll have a big, huge piece of a tiny little pie, or in fact, no pie most of the time, because they won't ever be successful. What you want to think about is your purple point here is on a much bigger pie. If you bring in investors, value add people, advisors, strategic alignment with other companies, you're going to have a lot of other shareholders and a lot of dilution, but your pie is hopefully going to be much, much bigger. Now, I think that's something to think about and be very cognizant of when you're worried about keeping every single founder share that you have. You might be actually setting yourself up for failure. So I think that's the end of my talk. And I can be reached there at lundquist.org or through this, however. I appreciate it. And thank you for listening to me. And we'll turn it back to Matt.
Thank you so much, Keith. Maybe we can have some discussion at the end here.
Keith, thank you so much for that presentation. And welcome back. I know you've been around for quite some time with regard to First Look. Were you on the original group that started up First Look? Or I know you were around earlier days when I was around it too.
Yeah, no, I think just 4 years I've been involved.
What's that?
I've only been involved for 4 years.
Got it. I feel like you're part of the old guard with Dina and Martin and Juan and all those guys. It looks like Matt's up, so I'll hop back off. Matt, take it away.
Great. Thanks so much, Darren. And thanks so much, Keith, for the initial presentation. So what I actually just was spending some time cutting out some slides in the interest of time here, but what I thought I would present on are the key intellectual property issues that an early stage biotech company should be thinking about. And one of those issues, to the extent that the IP is owned by a university or hospital, would be, of course, approaching the university or hospital and securing a license to that technology. But there's some preliminary stages before that in terms of building out the IP and assessing freedom to operate that I also want to talk about. I'll go through these really fast, just so you understand a little bit about the firm if you're not familiar. Wilson Sonsini is a global firm established by my partner, Larry Sonsini, and some colleagues about 50 years ago, more than 60 years ago almost now, next year, which is crazy to think about. But we're now 16 offices worldwide. And by the way, Larry is a founding member of the SoCal Alliance as well, which is a cool feature, and definitely gives everybody his best. Has been involved with this event in years past. We have 850 attorneys worldwide. We work with about 3,000 private companies and about 300 public companies, and that is split evenly between life science and tech. I work exclusively with life science companies. Before law school, I was a biochemist, naturally went into patent law, and now exclusively work with therapeutics, diagnostics, and med tech companies across the board in those sectors. One thing I want to plug is an event that I think is incredibly helpful for the community. Every year, Wilson Sonsini hosts a life science investor forum where we invite about 70 investors in the life sciences space and allow for clients and non-clients alike and academic institutions and hospitals to submit one-page executive summaries whereby the investors then receive the summaries for the companies that they're interested in and the space they're interested in, broken down by therapeutics, diagnostics, med tech. And we then connect them for a 40-minute pitch opportunity, whereby I think it's the only event where the investors actually pick the companies they want to meet with in advance, as opposed to trying to get their attention on the day of. So we're very much excited about that. And this year I'm actually organizing it. It'll be virtual, as to be expected now these days. And it's going to be the first week of December. So there'll be more information about that, and I'll be sure to include all of the institutions that are part of the SoCal First Look event for sure. So keep an eye out for that. We've had lots of great successes in establishing companies and financing them. Let me turn to my group, the patent group at the firm. We're the largest life science patent group in the country, over 185 professionals, focused on all aspects of life science. So really a robust team that is national practice. And I am one of the leaders in Southern California here, our San Diego and LA offices, where I spent my whole career, about 14 years now. All right, so let's talk a little about the current financing market in this pandemic, particularly with respect to IP. So surprisingly, or maybe not, but in any event, the case is that it's a very robust life science financing market at the moment. Certainly the strongest life science investor market I've seen in my career, and I think others have said the same that have been practicing longer than me. And I think that's largely driven by the opportunity to have IPO markets being open, right? Capital markets are open. That tends to open up opportunities on the earliest side of things, as we're talking about today with really seeding companies. That said, it's critical that your IP strategy is correct. And as great as the market is, we're seeing really high valuations. Investors are really scrutinizing intellectual property strategies, so it's critical that you have your IP strategy correct. So when I talk about an IP strategy, what am I saying? I'm saying two things. One is that you really have to have your patent portfolio figured out, and two, FTO, right? So the first item I have listed is FTO, freedom to operate. And I listed that first. Typically, most investors would consider FTO to be the single most important intellectual property issue for a life science company. And the question there is whether or not your product or service, when you get to the market, will infringe somebody else's patent, right? So the patent gives the owner or its licensee the right to exclude somebody else from 5 things: making, using, selling, offering to sell, or importing whatever is defined by that patent. So if you're going to be launching a product and somebody else has a patent in your space, you need to know about it, and you need to make sure that you don't infringe it. Otherwise, they could exclude you from the market or require you to pay significant royalties to the point where it doesn't make commercial sense to proceed. So investors will not tolerate much, if any, risk on the FTO front. So it's critical that before we have an IP diligence call at the earliest stages, say a $10 million investment, seed or Series A investment, you're going to get a lot of questions on that. The second most important issue is building out your own patent portfolio to protect your product or service. So here, just as an investor is not going to want to spend $5 million of their $10 million investment on fending off a patent litigation because there's an FTO problem, that investor also will not want to spend $10 million of their investment bringing a product to the market only to have, upon commercialization, somebody copy you, right? Or even just trade off your goodwill. So for that reason, it's also critical that you build out your own patent portfolio. And all of this IP strategy that I'm describing is designed to secure financing initially and ultimately to enable an exit for the founders and the investors alike. So in the interest of time, I could go through a lot here. There's requirements for obtaining a patent, right? The second item I mentioned, you have to satisfy certain requirements with the patent office. I'll mention them briefly, and then I'll mention very briefly what we call a patent lifecycle strategy, which is designed to make sure that we have a patent protecting our product for each day that the product is on the market. We don't want to have to withdraw a product from the market, especially in the therapeutic space, because the patent is expiring. Talked about FTO. I'll show one slide on that, and then let's talk a little bit about some university licensing terms and some trends that we're seeing when approaching the university. In the situation where the patent that I'm going to talk about next in terms of the requirements to get, in the situation where that patent was created at the university owns it, you got to approach them to get the license. So let's talk first about the requirements for patentability. There's 4 substantive requirements that you want to think about. Subject matter eligibility. The question there is whether or not the invention that you're working with is the type of invention that the patent laws will protect, right? Generally speaking, United States especially, patent laws tend to be fairly broad. That is, a lot of things are patent eligible. We have to pay very special attention in really 3 areas. One, software. There's a recent Supreme Court case, Alice, that has really scrutinized whether or not software is too abstract to be patented. So very special attention there needs to be had when drafting a patent application in the software space. Same is true for diagnostics. A case I actually worked on, Prometheus versus Mayo, Supreme Court case that made it difficult to patent natural correlations. So a lot of diagnostic patents are looking at a biomarker, for example, and drawing a conclusion, a medical conclusion based on that, whether it's a therapeutic recommendation or adjusting a dose or the like, or selecting patients even from a companion diagnostic perspective. So we have to pay very special attention there. And then the last bucket that we have to be very careful about is natural products. That's the Myriad case, which held that certain natural occurring genes, for example, are not patent eligible. In that case, the BRCA1, BRCA2, breast cancer genes, Myriad sought to exclude others from using in a test, and Supreme Court held that you cannot patent naturally occurring subject matter. So that said, there's ways to go forward. So if you're in any of those areas, it's not as though you have no chance, but you want to be very careful about how you go about it. Second requirement is novelty. In order to get a patent, of course, your idea needs to be new. Critical that we think about that issue and make sure that in the university setting especially, the inventive group has not already published on what you're trying to patent. Happens all the time, right? There's a currency in universities that publish or perish, right? So if you're thinking about commercializing your invention, one of the most important things I can say today is just think carefully about getting that patent filed before you make that publication. Inevitably, with pretty much any spin out, there's going to be some publication out there. Hopefully it's not one directly on what you're trying to commercialize, and hopefully it's just something that is more state of the art. But that's a very important issue, and Keith mentioned it as well, rightfully so. The third requirement is it needs to be inventive or non-obvious. So just because your idea is new, meaning that there isn't a single reference that came before that teaches that idea or invention, you also have to be inventive. So it can't just be a trivial, obvious variation of what somebody else did. It has to be a significant leap or inventive. And this is more of a subjective requirement. And I could spend an hour talking about, or maybe more, talking about how we deal with obviousness rejections. But that's really where patent attorneys earn their pay, so to speak, and can be very difficult issues that arise from an examiner who's stuck thinking that this is just a routine improvement upon what was done before. And we've developed a lot of creative ways to really flip them on that issue. And the fourth requirement is the disclosure requirement. So you have to teach others how to make and use your invention. And this is more on kind of like the first requirement where you really need to think about what area you're in. Here too, it's not really on your patent drafter to make sure they do a good job on that issue. So 4 main requirements. Again, I could go on through each, but generally speaking, when we're thinking about a life science portfolio, what we really want to focus on is building out a strategy. And what I'll cut to the chase here on this slide, at some point during the process when you file a patent, your patent application is going to publish. Once that patent application publishes, it can then be prior art to your later filings. So what we try to establish early on is what we call a life cycle management strategy, where prior to the publication of the first family, we'll file a second patent family. And each patent family will have 20 years of duration, thereabouts. So the goal would be to maximize, each time you have an improvement on your product, maximize the patent term and minimize the earlier filings from being prior art to you. So there's lots of examples here I have. This is a laboratory diagnostic test example. The same can be applied to the in vitro diagnostic pathway, which was a 510K typically under class 2. A PMA, if you have a companion diagnostic, there's strategies that we would implement, all designed to maximizing your patent term, minimizing your prior art. And now when you get into the more rigorous FDA paths, you start to have the opportunity for exclusivities, especially in the therapeutic context. And with therapeutics, you'll have both patent exclusivity and regulatory exclusivity, and all of it needs to be aligned. So it's really important that you're aligning your patent strategy with your regulatory strategy. Let's turn just briefly one slide to freedom to operate. It's a really important aspect. So thus far, we've talked about on the preceding slides about how you obtain a patent that protects your product or service. FTO, again, is looking at whether or not there's a risk of patent infringement from a third party suing you based on your commercialization of your product or service. Whether or not you have a patent on your product or service is irrelevant to the issue as to whether or not your product or service infringes somebody else's patent. It's certainly possible, and in fact common, whereby a third party may have a platform patent, right, from initial concept. You've improved upon that, intentionally or not, and you've obtained your own patent. And even though you have your own patent on an improvement, you would still need to have rights to that platform patent in order to commercialize, or wait till its expiration or design around it. But you still would have to deal with it in one form or another. So that's freedom to operate. These are all aspects that the company should be thinking about, right? Patentability, creating your own patent portfolio, freedom to operate, whether or not your product or service will infringe a third-party patent. Those are things that the university, generally speaking, will not be advising the startup company on, right? The university certainly will have its own patent counsel ordinarily, prosecuting the patent. But that's still not, they're not really in the position to give you advice as to what the patent strategy is. It's really more on the company to come up with that. The company's in the position to where they understand what the commercial product will be. They're in a position to work with the technology transfer office and obtain a patent that makes sense for both parties. And on the FTO piece, there's really nothing that the university typically will have done. That's completely on the company. The question there is whether or not the company's product or service has any risk for that type of liability. So it's really important that you've thought about those aspects. It's important that you've done your diligence, right? Both from a commercial diligence perspective and an IP diligence perspective before you approach the university for a license. Let me go over these real quick. I can't mention enough how important it is, especially working with university groups, that whatever you do, make sure that you think about filing a patent before you give any type of talk, any type of symposia or an abstract. Even an online early publication, that's a publication, right? Before the actual journal peer review process is complete, that still qualifies if it's accessible. So anything that is not under NDA that can be accessible is an activity that can prevent you from getting a patent on whatever's published. Even if you have An NDA, though, I still recommend that you file a patent before you have that discussion, before you share the idea. Not because I think people are nefarious, but I do think people tend to forget where they hear things if they're not being very careful about it. So generally speaking, file your patent first. If you want to then have a discussion with an investor, a party, partner, potential partner, have an NDA in place, and then if you need to publish for some other reason, fine, but just make sure you've adequately filed it in the patent before. Ideally, you don't have to publish. You're just giving people a head start, but I understand there are academic pressures that whereby it may make sense to file first and then publish. All right, so let's talk a little bit about university licensing. So what I commonly advise my clients that are looking to spin out technology from a hospital, university, or institution is that the university will own the IP. Sometimes faculty members are surprised by that, even though they're an inventor. That's actually what they're employed to do, right? And so therefore their employer, the university, will own that IP. That's true even if they become a consultant for the company. As long as they're still at the university or institution, that institution will, generally speaking, own the IP that relates to the work that they're doing. You just have to look at their publication record, and that's fairly easy to figure out. The IP will be managed and licensed by the Technology Transfer Office. Generally speaking, and I'd say well over 95% of the time, not higher, the inventing faculty members will stay on at the university or institution and continue in their role. They will generally receive some share of royalties that the institution receives, and that's dependent, on the institution and the IP policy that they have. A lot of times they'll become consultants, so the faculty members will become consultants, maybe chair the scientific advisory board, and that's a great spot. One of the maybe more important things I could say is that's a really good spot for a faculty member. Being the CEO may be difficult, maybe near term if it's permitted, workable, but in the long run, it's going to be difficult for that to get funded in the long run. It's certainly possible, but I think the ideal scenario would be heading up the scientific advisory board and maybe having a departing postdoc become the temporary CEO until you find a professional CEO. Generally, we try to encourage companies to innovate new ideas outside of the laboratory setting where the idea came from. Otherwise, if you just use the university lab as the company's pseudo lab, the company will never own its own IP, right? They will constantly be licensing IP from the university, and that's fine. Nothing wrong with that, not improper, but the goal really for a spin out company is to spin out, right? So the sooner we can get laboratory space, grad labs through Alexandria is a great option here in San Diego. There's others as well, but the point is find suitable space and try to do two things during that early stage process, which is repeat the laboratory work that was done and maybe consider accelerating that patent prosecution process to see if you can actually get a patent. Both could be done under an option agreement. So let's talk a little bit about that. What are some of the ways that you can get access and commercial rights to IP so that the university might own? One is by way of an option agreement, and I alluded to that. I love the option agreement, especially for a company that has very little funding. So what you could do there is defer the process of negotiating the full license agreement in all its terms, and instead have a 12 to 18 month period where the university will not talk or engage in any discussions with anybody else. You at the company will have the opportunity to test out the technology, ideally try to reproduce the work that was done in the lab on the one hand, and then on the other hand, you can also negotiate terms in that option, material terms, which you'll see on the slide here, that could then be implemented in a full license agreement later on once you exercise that. So you're putting forth some effort to understand what the material terms are, and that's advisable because you're going to be investing value into that technology. So you want to make sure that you have some idea as to what you'll end up paying. And one of the things you could do is then expedite patent prosecution and try to get a patent under what we call the Track 1 program, try to get a patent issued during that option period. Because ultimately, majority of these deals, they're just patent licenses, right? So if ultimately the patent is not going to issue, or not going to issue in a format that is suitable for you commercially, that will protect the product, then you should know that, right? If there's a know-how component, then it might be a little different. But those are the two things that I recommend a company do. Consider entering an option. Talk to your tech transfer office. They'd have to have that option available. But that's a great way to go. And then what you would negotiate is a term sheet, which has these material terms here. And Keith went through some of them. So the upfront fee that we often see is a certain amount of cash that you will pay the university, generally a smaller amount, anywhere $5,000 to $40,000, depending on the technology, how far along the technology is developed. For a therapeutic, if there's human data, that's super helpful and generally more expensive because of it. But as Keith mentioned, equity can be an offset, a trade-off for the upfront fee. So if you have no cash, consider giving the institution equity, single digit, lower single digit amount of the company up front, typically with some anti-dilution protection, which is unique for the university. So it's somewhat foreign to folks that are not used to university licensing as to how that can happen. But there is some anti-dilution where the university or institution will have a certain position of the company up until a certain amount raised. And then royalty, which, very important term. A lot of investors would consider as the most important term because, the upfront equity, that's on the founders to split up. But the royalty is going to be an obligation on the company forever, right? As long as they're commercializing that IP. So spend time there. Milestones are payments that you would make at certain inflection points. Ideally, we try to tie any payments to the inflection point so that it's offset by your increased valuation, and therefore it's doable. Sub-licensing revenue is a portion of any non-royalty income that the company receives for authorizing third parties to use the IP. And there we try to have a step down over time or based on events. And then an important economic term is patent costs. A trend that we're seeing is universities allowing you to write off and not have to repay patent costs for a certain amount of equity, which I think is super creative and aligning in interests. Or at least allowing the company to reimburse the patent costs. These are the patent costs that the university incurred through their counsel in obtaining the patent that you're licensing. So, they were there looking out for the asset before you were even thinking about a company. So one way to think about that. So they should get reimbursed, but it's nice to have some flexibility in time and when that gets repaid. And then there's a whole lot of non-economic terms that you'll want to negotiate in a term sheet, whether that term sheet is attached to an option agreement or ultimately forms part of a full license agreement that you negotiate right away. Depending on the situation, both would work. But there's certainly other aspects. We generally want to see all fields. Investors hate to see lack of all fields, at least all therapeutic commercial fields. There's always going to be a reservation of rights for the institution to do research. And exclusivity is king for therapeutics. There might be a research tool situation where maybe it's not exclusive, but generally speaking, it's normally exclusive for life sciences as well. So I'll stop there. We have a few more minutes, Keith. I've been trying to watch the clock best I can. Anything I said incorrectly, Keith, that you should correct me on?
No, I think that was great. And I'm glad you brought up the fact that, patent costs and things can creatively be turned into equity. I mean, my opinion on that is it's a win-win for both. So yeah, no, I think you covered it really well.
Thank you guys for that informative information. I think it was really exciting to me to hear that Keith's at the Lundquist Institute and taking his sort of brand of technology transfer to a really powerful organization. And Keith's been around the ecosystem for a really long time. So thank you for all your perspective and your hard work, Keith. And thanks for being part of today.
Thanks a lot.